the Child Care and Protection Act. Section 10, prohibition against sale or trafficking of children. Subsection 1. No person shall sell or participate in the trafficking of any child. Subsection 2. Any person who commits an offence under subsection 1 shall be liable to conviction on indictment before a circuit court to a fine or to imprisonment with hard labor for a term not exceeding 10 years, or to both such fine and imprisonment. Section 11, warrant to search for and remove child. Subsection 1. If it appears to a justice of the peace on information on oath laid by any person who, in the opinion of the justice of the peace, is acting in the interests of a child, that is reasonable cause to suspect A, that the child has been or is being assaulted, ill-treated, or neglected in a manner likely to cause the child unnecessary suffering, or B, that any offence mentioned in the second schedule has been or is being or is likely to be committed in respect of the child, the justice of the peace may act in accordance with subsection 2 or 3. Subsection 2. The justice of the peace may issue a warrant, A, authorizing any constable, 1, to search for the child, and if it is found that the child has been or is being or is likely to be assaulted, ill-treated, or neglected in any such manner, or that such offence has been or is being committed in respect of the child, to remove the child to and detain the child in a place of safety, or 2, to remove the child with or without search to a place of safety and to detain the child there. So that means a justice of the peace can get information if somebody ill-treat the child, and then the justice of the peace will authorize the police constable to come and take the child out of the home, alright, and bring the child before a children's court, or if there is no children's court sitting in that parish, before a resident magistrate in chambers within 48 hours after such removal, or B, causing any person accused of any offence mentioned in subsection 1 in respect of the child to be apprehended and brought before a court of summary jurisdiction, in order that proceedings may be taken against him according to law. So you can take the child to the children's court within 48 hours of such removal, or make the person who is the abuser, appear before a court. Alright, subsection 3. Instead of authorizing the removal of a child under subsection 2, the justice of the peace may make an order prohibiting any person accused of any offence mentioned in subsection 1 in respect of the child from A. Entering or remaining in the household resident where the child resides, or B. Following or laying the child in any place until such time as the child is brought before the court. So the court can order that the person suspect of being the abuser, they can prevent the person from going to the same house with the child or keep certain distance from the child and the school where the child goes. Alright. 4. A copy of an order made under subsection 3 shall be served personally on the person accused of the offence, who may apply immediately to the justice of the peace for the order to be discharged. Okay, so if you get an order from the police, so you're suspected of abusing the child, and you must appear before the court, then probably, based upon what it says, you can actually apply to the justice of the peace to remove that order, maybe explain the situation or so. I guess so. Alright. Subsection 5. In determining whether to discharge the order, the justice of the peace shall have regard to the matters referred to in subsection 1. Subsection 6. Any constable authorized by warrant under this section to search for any child or to remove any child with or without search may either, if need be by force, may enter if need be by force, that means they can kick down the door, any house, to enter any house, building or other place specified in the warrant, and may remove the child therefrom. Subsection 7. The constable executing any warrant issued under this section may be accompanied by the person laying the information, if that person so desires, and may also, if the justice of the peace by whom the warrant is issued so directs, be accompanied by a duly qualified medical practitioner. So when the police come for the child, the person who make the report can accompany the police. And depending upon the nature of the situation, a doctor can, or maybe a nurse can also accompany the police to get the child. Subsection 8. It shall not be necessary in any information or warrant under this act to name the child. So they don't necessarily have to give the child's name. Alright. Detention of child in a place of safety. Second schedule. So that is section 12. Subsection 1 of section 12. A constable, a children's officer, or a probation and aftercare officer may take to a place of safety any child in respect of whom any of the offences mentioned in the second schedule has been committed, or there is reason to believe has been committed, or who is, in accordance with the provisions of section 13, about to be brought before a children's court. 2. Any child taken to a place of safety under this section, or any child who seeks refuge in a place of safety shall not be detained there for longer than 48 hours without having been before a children's court, or if there is no children's court sitting in that parish, a resident magistrate in chambers.